Webinar is set to start here at 11 a.m. Eastern time. We'll get started here in a minute. Looks like there's still a number of people hopping in, so hold tight and we'll get moving in about a minute. All right, it is 11:01. We're scheduled to start at 11. Looks like a number of people are still joining, but that's okay. We'll get moving. Thank you all very much for joining for our Tag Inspector webinar here today. We'll be discussing cookies and consent, some of the recent guidelines or updates put out around cookie consent, what that means for your organization, how that plays into overall data collection, and some of the different things that you should be focusing on as a result. To start, just a little bit of quick housekeeping items. These slides want to work. So about Tag Inspector and me, my name is Lucas. I'm our Tag Inspector product manager. Also do quite a bit of tag management and tag governance consulting work. So at Tag Inspector, we're a tag auditing and monitoring platform. I work with thousands of websites. We do a number of educational programs as well, including these series around all things tagging, all things tag auditing, all things tag governance. Quick disclaimer, even though we are talking about consent and some legal topics around what is compliant data collection, what is compliant consent, this is not meant to be legal counsel. We're so just wanting to discuss these various different topics, go through some of the different guidelines and some of the requirements. Ultimately, what needs to happen is you need to take these things to your own in-house legal counsel for approval and for the policies at your organization. But hopefully this can be educational and can provide a little bit of guidance for where you need to start and what are some of those things that you should be raising to them. So real quick, in terms of the agenda, what we'll be going through first is just an overview of tags and cookies. Oftentimes the two things get confused. And it's really important as we talk about some of the laws and regulations as it relates to compliance, as it relates to consent, that we understand the difference between the two and how they play together. So what tags are, what cookies are, and yeah, the intersection of the two, and then how the different laws and regulations relate to those technical items. From there, we'll be going through the rules of the game, just a quick overview of some of the different laws and regulations that we're having to keep in mind as it relates to specifically here consent and what compliant data collection and use of cookies is. We'll then go through some of the more recent guidance and just the status around ePrivacy. And that is what speaks directly to the use of cookies here in Europe. As well as what you need to keep in mind for compliant consent. We'll then talk about what the impacts of all of these different things are for data collection practices, for targeting, audience creation, all of those things, and then some best practices just to keep in mind to make sure that you are optimizing your data collection and digital technology usage. And then finally, we'll wrap up with a quick summary and some Q&A. One thing that I like to do as we go through these, if you have questions, please drop them into the questions pane, which you should see just within the control panel that you have for GoToWebinar, which we'll be using. I like to keep this a little bit more of kind of a discussion. So if you have questions that come up, throw them in there. It's related to the topics and what we're discussing at that point. We'll go ahead and address them. and yeah, keep it fresh and hopefully keep it very beneficial and educational for you in that way. The one question that I'll go ahead and answer, yes, so we will be following up with recording of the webinar as well as the slide deck. So rest assured that you will have some content to take away following the webinar. Cool. So with that, we'll jump right into it. So first topic here around just the tags and cookies. So first, when we're talking about tags, we're talking about cookies. What are we talking about? So what tags are, to make the designation between the two, tags are the JavaScript scripts that run on your website that correspond to different marketing, advertising, analytics technologies that are in use. So this here, you can see that red box, that's an example of a tag. So JavaScript, this specifically is related to Google Tag Manager. And how these work is when your web page is loaded, the browser goes through, scans everything, and those are just commands and as it's going through that, it's going to initiate those tags. What those tags do is they send a request up to the server. So say you're using Google Analytics, sends a request up to the Google Analytics server. It's going to return a full, larger script that's going to run, and that's going to collect the different information from the page, from the user, from the browser, and then send those hits up. So tags are responsible for data collection, and they're responsible for the actual functionality of the different marketing, advertising, analytics platforms that are loading on your web pages. In addition to that, well, first, just a quick example here, screenshot. This on the right-hand side of the screenshot are examples of tag requests. And those are the actual things that are sending the data up to those various different platforms and those various different servers. So this is the method through which data is being collected from your website. Now, in addition to sending up the information or the data, when tags run, they're also setting cookies on the user's browser. So cookies are just little text snippets that basically save information on the user's browser. So that might be like an anonymous ID, that might be information about like what is being saved in their shopping cart. Maybe if you have some login functionality, it might be like the username, password, just to keep them logged in. But cookies are not inherently data that's being collected. The data is not being processed yet. As you know, we're talking for something like GDPR. Cookies are just information to be saved, to be written, and then held on to for later on the user's browser. Here's an example here on the right side of this screenshot are a number of first-party cookies that are set there. So they live in the browser, and it's not data that's being collected at that point. Now, it's important, this designation is extremely important as we talk about consent and the different laws and regulations. So we'll go through a little bit, but things like GDPR in Europe, CCPA in the US, those are related to and speak directly to information or data that you're collecting or processing from a user. That's what the tag is sending back up to those various different platforms. Things like ePrivacy, technical protections such as like ITP, ETP, those are speaking directly to cookies and what the requirements are for the use of cookies. Now, they're related together, data that's being collected, data that's being processed, and cookies, because tags, those JavaScript snippets, are the method through which both of those things operate. So again, it's important to just to reiterate here, data that's being collected and data that's being processed is different from cookies that are being accessed and cookies that are being set. Data collected is sent to the servers, cookies are saved on the user's browser, potentially for use later. And when we talk about consent, so if you're using consent, for example, as your legal basis for processing under GDPR, that relates to consent of the data that's being collected. When we talk about consent through the lens of ePrivacy, that's relating to consent to the use of cookies. So again, two separate things that are connected together due to how technologies currently work. and that both are the method through which both are being collected or set, or the method through which both are happening is via the tags on the website. So now that we understand tags, now that we understand cookies, the separation of each, as well as the method through which both of those are being collected, being used, it's now important to talk about what I call the rules of the game. So these are the various different laws, regulations, and requirements that you have as an organization that lay out the requirements for things like consent and the requirements for the rights and the protections that are afforded to your users, and that we have to keep in mind when we're talking about compliant data collection and compliant use of marketing and advertising platforms on our digital properties. So in terms of the rules of the game, what are these? Really, the big ones to keep in mind is going to be for the US and really globally, because global organizations are going to have a presence in the US, is going to be CCPA, or the California Consumer Privacy Act. Again, this speaks to the rights of users or afforded to users with respect to their personal information, what you can do with that, transparency into personal information being collected, how it's being used, shared, sold, all that. This law goes into effect January 1, 2020. Enforcement begins for this law July 1 of 2020. The second main requirements or legislation that we need to keep in mind for any users or any organization with users in the EU or web presence in the EU is GDPR. This is currently in effect. It's been in effect for over a year now, and many organizations, well, all organizations that have a global presence should be aware of this. The next one that we're going to talk about are ePrivacy directives. These are currently in effect, and these are the cookie laws that are in place. And these are currently country specific. They're working on what they're calling the ePrivacy regulation, which is seeking to codify all of those individual member state requirements and member state directives. And we'll talk about some of the requirements as they're outlined within the most recent draft when we get to that section on just ePrivacy guidance. Other things to keep in mind as it relates to data collection, the use of cookies and consent is also different technology initiatives that are being rolled out by browsers, by these technology vendors through which users are accessing your website. So many people are probably familiar with Apple, their ETP. That initiative is really the most widespread, the one that has the largest effect. We'll speak a little bit to what exactly that is trying to protect against or the restrictions there. Firefox has ETP, which is very similar to Apple's ITP for anyone that's using Mozilla and the Firefox browser. And then Chrome has some requirements around cookies that are going to be rolled out in a release at the beginning of February. That is mostly speaking, or that mostly just deals with transparency for users being able to more easily view and control different cookies that are being set, as well as some requirements for the organization to make sure that cookies are secure and only used for same site purpose. In addition to these, which are more broad, depending upon the industry or the vertical that your organization might be in, there might be some industry-specific laws and regulations. Financial industry, for example, has some of their own laws and regulations around data security, privacy. If you have any properties that are targeted towards children, things like the COPA, Children Online Privacy Protection Act, might also be in play for your organization as well. So to get into these a little bit more and speak specifically to them as it relates to consent. So California Consumer Privacy Act, the CCPA, what that does is, at its core, is affords a number of different rights to residents of California as it relates to personal information that's being collected about them. Again, it's very important here to really note that this is speaking to that personal information. So it's related to the data collection and then what you're doing with that data. CCPA is not speaking directly to the use of cookies or the placement of cookies on the user's browser. You can see the rights here that are afforded to Californians with respect to the personal information. It's mostly around transparency and then the ability for them to access, request, and request deletion of any of that personal information, as well as rights for them to say no to the sale of personal information. The second big one here, GDPR. Again, GDPR affords rights to anyone within the EU or any EU residents in relation to their personal data that is being processed. Again, this is relating to data that's being collected, data that's being processed, data that's being used. GDPR, again, does not speak directly to the use, placement, or accessing of cookies on a user's browser. You can see here the kind of core 8 rights that are afforded to users. There's a lot of requirements that kind of fall under these. But one thing as it relates specifically to consent is that users, you must have, as an organization, a legal basis for processing any type of personal data that is being processed from users. Processing includes collection. It's anything that you're doing with any personal data point. And one of those legal bases for processing that could potentially be in use by your organization for marketing advertising data would potentially be consent. Now, the requirements for consent under GDPR are that it must be unambiguous, specific, and informed. So what that means is just that consent to data processing or the processing of personal data, if that's your legal basis for that processing, must be explicit. No pre-ticked checkboxes. The user must explicitly be saying, yes, you have my consent to collect this information. We'll get into some of those consent requirements a little bit more here as we move forward. Again, GDPR, CCPA related to data collected. ePrivacy directives are relating to cookies. So the placement, the use, the accessing of cookies. These are the things that are speaking directly to the use of cookies. One thing that I often run into in speaking with clients and partners about some of these different privacy laws and about consent is that they'll start talking about, well, I can't use these cookies, or I require consent for these cookies due to GDPR. GDPR speaks to data being collected, but it does outline very specific requirements for what valid consent means. It's not a given that you're using consent as your legal basis for processing of marketing and advertising data. You could be using legitimate interest as outlined within the GDPR text. If you want some more information specifically about the GDPR and the requirements for consent, there are a number of resources already on the Tag Inspector website that might be helpful in that regard. But as we talk about cookies, again, these are the ePrivacy directives. So what this is, it's a long-standing directive that was put out here in the EU that just requires all the various different member states to pass their own laws and regulations with respect to the use of cookies. And all of that really comes down to transparency and then consent requirements. These requirements, as of today, are going to be different. It's going to be country specific. Here are a few just examples of some different country requirements. The UK, and one thing we'll be talking about is the actual ICO guidance as it relates to this. But in the UK, consent must be freely given, specific, and informed, an unambiguous positive action. Basically what their clarification and guidance did, the ICO, which is the kind of the governance body in the UK, tied the requirements for consent in consent of a user for you to be able to use cookies or place cookies on the browser, tied those requirements to those as they're outlined within GDPR. Again, other countries have some different requirements. The best means of accessing the most recent requirements for each country is to visit each country's specific governance body's website. In addition to these laws and regulations, we also have some technical measures that are in place. So as mentioned before, the biggest one is going to be ITP. The most recent iteration of ITP is 2.2. Basically what it does is makes third-party cookies realistically unusable. And then first-party cookies, it places some additional restrictions on those that speaks really directly to the amount of time that those are going to persist, or that information that you're storing in that cookie is going to live on a user's browser. So for any first-party cookie, at most, the expiry date on that is going to be 7 days, which means that a cookie is only going to be present on a user's browser for 7 days. And that expiry could be only 24 hours if the user is coming to your website from a known advertiser domain, and if that link has query string parameters, which are just some additions of information that can be appended to a link that are going to help with things like analytics, for example. So basically what this means, if your traffic is coming to your website from, say, a Google paid search ad, that link is going to have query parameters, and it's coming from the Google domain. The expiry on any cookies that you're setting, even first-party cookies that you're setting throughout that session are only going to be 24 hours. The implications of this is basically just that it's more difficult to use cookies, and you're not going to be able to place cookies that can be read across other websites, which has a big impact on advertising efforts, targeting, retargeting, those types of things. When we think about all of these things, and just to kind of summarize and distill it down, there's really 3 core principles that all these different rules are speaking to. So the first one around requirements is going to be for transparency and disclosure. Transparency needs to be in disclosure at the point of collection or the point of processing any data that's been collected from users. And then, just giving the user that transparency, so they can understand what's being collected, how is it being used, what is the impact on them. The second core principle spoken to in these various different rules is going to be access rights. So both CCPA and GDPR provide rights to users for them to be able to request any personal information or personal data that you are collecting about them, be able to move that, so it needs to be in kind of a well-formatted and organized format, and then also the right to request deletion of any of that data. So practically, or in practicality, I guess, in practice, what this means for you is that you need to understand what data is being collected, where it's going, and then be able to access it and be able to provide it to a user, as well as potentially delete that if they request you to do so. The final piece here is around refusal or objection of processing. And this is really when we get into consent. So under GDPR, the user has the right to refuse to all processing activities. And again, GDPR speaks to data being collected. So with GDPR, if someone opts out of the use or the processing of data, you can no longer collect that data. Now, if we think back to our original section around tags and cookies, the method through which data is being collected is the execution of a tag on the website. So to stop the collection of data, we need to stop the tag from executing, which is going to have the effect of no cookie being placed as well. Under CCPA, the rights of the users around refusal or objection is just to the refusal of the sale of personal information. It does not extend all the way back to the processing of that information. So if you have a means of, if you are selling personal information of a user and they're opting out of that sale, if you have a technical means of just not selling that data, you can still collect it. So for something like analytics in Google Analytics, while many things you're collecting in there would fall under the definition of personal information under CCPA, them refusing the sale of that information, if you're not selling that information, you can still collect it, you can still use it for the purposes of analytics that you're kind of currently doing. And again, this relates to the collection and the use, sale, sharing of that data. It's not speaking directly to cookies. Now, under ePrivacy, that refusal or the objection of processing, it requires consent for the use of cookies. This is where we're talking about cookie consent. Now, for all practical purposes, again, cookies are set when tags are executed. In order to stop a cookie from being set on a user's browser, for 95% of platforms and how the internet and how all these technologies work today, it requires you to not execute that tag. As a secondary kind of effect of that tag's not executing, which means that cookie's not being placed. Good, user hasn't consented to it yet. But that also means that data is not being collected. So that's where these cookie laws and these different requirements and the more stringent readings of these laws, now requiring explicit consent in many cases, are also impacting things like your web analytics. Because the means by which you stop cookies from being set by various different platforms also requires that the tag cannot be executed. You don't have a means of collecting data for things like analytics, attribution in a traditional way. The final piece here around technical limitations, so something like ITP, even though there's the restriction on cookies, again, those tags are going to be executed, those cookies are going to be placed. What ITP is doing is basically just wiping those away. So you're still able to collect that data. ITP is not blocking data from being collected. It's not stopping tags from running. It's just stopping cookies from being able to be saved on that user's browser or device. Now, that doesn't mean that your data collection practices are going to be not impacted at all. All these different technologies, using something like an analytics platform, for example, they rely on those cookies for some of those different pieces of reporting. We'll use Google Analytics as an example, because it's the most commonly used analytics platform. Cookies are used for the designation of a session as well as a user. So if the expiration of cookies is only 24 hours, if a user comes to your website today, cookie set, identifying them as just unique anonymous user. If they come back again tomorrow, they're going to be, for purposes of reporting, they're going to show up as a new user because there is no means of being able to identify them as a user that's already come to the website before. So there are going to be some implications and some impacts on tracking, but those technical things are just related to cookies, and again, not data collection. Cool. So those are the practical requirements and kind of the rules of the game. Now, let's speak to the ePrivacy, some of the guidance. So these ePrivacy laws, these cookie laws, and as it speaks to requirements for consent to the placement and accessing of cookies, they're constantly, well, I shouldn't say they're constantly changing. The laws are not changing. The laws are staying as they are. Well, literally, the actual words are not changing, but the interpretation of those laws is evolving, and new guidance and new requirements or interpretations are being put out by various different governance bodies in some of these different countries, as well as mentioned before, ePrivacy, they're working on codifying all of these so that there's a standard across all the EU, as opposed to individual countries having their own rules and requirements. So in this section, we'll speak to some of the more recent developments and then what that means for consent. So the first thing I want to go through here is just the current iteration or the current draft, most recent draft update to the ePrivacy regulation. So what the ePrivacy regulation is similar to GDPR. It is the requirement across all of the EU, and it's working to codify these individual country requirements for ePrivacy directives. one of the main things in here is it's putting forth the requirements for consent. One thing within the first item to really note within the most recent draft is that the definition of consent, or the requirements for consent, it is tying it to the requirements as outlined within GDPR. So the wording within GDPR for consent of the data subject means any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. So again, GDPR relating to data collection, but it's giving you very, very specific requirements for consent. What the ePrivacy regulation in its current iterations, current draft, is tying consent for the use of cookies to the same wording of consent within GDPR. So this is explicit, unambiguous consent. You will not be able to set cookies prior to a user explicitly accepting the use of the placement of those cookies. The implication here for data collection, again, is that the method through which you stop cookies from being set is by stopping tags from being run, which also has a secondary impact of data not being collected. The second thing to really note here within the draft is that the draft explicitly indicates that consent can be obtained by appropriate technical settings of software. This is a question that we get very, very often, is that can consent be granted to an individual software provider and then applied across various different websites? In its current iteration, it is explicitly stating that yes, that is the case. So for purposes of, say I'm using like a marketing platform, or sorry, an advertising platform, as a user, I have consented to, within like the terms, within my own personal user account with that particular platform, that yes, they can personalize advertising and target that to me. That consent that I have, and me saying yes, I accept for you to be, able to place these cookies, and for the purpose of personalizing ads to me that I give to that platform or to that software provider, would be able to apply across different websites or different sections of the internet that I go to that are leveraging that software. So that is that clears that up a little bit. It's going to be interesting to see how that's actually applied in practice. But the intention here, and as it seems, is that it makes the practice of granting consent a little bit easier for me as a user, as opposed to having to consent or making a consent decision every single place that I go, which can be very, very cumbersome. The last thing in here to note of the current draft is that there is an update and a recital in here that addresses the issue of cookie walls. I get a lot of questions about cookie walls as well. What those are just anything that stops you from a user from interacting with the site content until a consent decision has been made. It is saying in the most recent draft that it is indeed possible that I can use a cookie wall and I can require consent to the use of cookies in order to get the same web experience or the same experience with that particular digital asset as I would if I was not granting consent. Now, that doesn't mean there are protections that you can't discriminate against users for not granting that consent, but I can require consent or require a consent decision prior to them accessing my content. So that's the most recent draft. This is not law. This is just how it's written right now, but things to keep in mind as you're thinking about your consent strategy and compliance strategies for your organization. The next thing to cover here is recent guidance that was put out by the ICO in the UK. The ICO is the kind of governance compliance body within the UK. And according to the ICO, PECR, which is the ePrivacy Directive within the UK, it requires that users consent to cookies being placed There's no definition of consent within Pecker, but their guidance or their interpretation instead, now that GDPR is out, requires consent to follow the guidelines as outlined within GDPR. Again, what this means is that a user must make a clear affirmative action in consenting and accepting to the use of cookies, not just the use or not just the processing of their personal data, but also for the use of cookies. So again, I cannot run or execute any marketing, advertising, analytics platform on my website with an audience in the UK, so in my UK websites, until a user has explicitly granted consent for my use of those cookies. Again, it has an implication on data being collected because tag's not going to execute until a user has consented as well. So there's also going to be an impact on just the volume and the nature of data that you're able to be collected. But this requirement is not specifically related to that data collection. Again, it's the use of the cookies. Another recent interpretation or reading, I guess, that came out was in the beginning of October. There was a law case that made it all the way up to the Court of Justice for the European Union, and they put forth an opinion on that. So a little bit of background on this case, and if you follow all things privacy and governance, you maybe have heard about this. But Planet 49, it's a German company, and what they did, they hosted a lottery on their website. In order to join into the lottery, you were required to put in your name and address as requirements to register. Below those areas where you input that information, there were two checkboxes and two options. The first option was an unticked checkbox for consent to be contacted by sponsors. The second one was a pre-ticked checkbox for consent to the use of cookies. Participation in the lottery only required the checking of that first checkbox or the first option. And this case was referred to higher courts in order to get an opinion on the validity of consent to the use of cookies with that pre-ticked checkbox. So basically, in essence, what this was doing or contending was the requirement of explicit, so that positive affirmative action of actually checking a checkbox in order to say, yes, I consent, versus an implicit acceptance of consent that by just making no action, that constituted valid consent. The opinion put forth by the court here really had very long, a little complicated, but the core findings here was that one, pre-ticked boxes do not amount to valid consent. So it kind of says that that implied consent does not constitute valid consent. Also explicitly stated that the expiration date of cookies and third-party sharing needs to be disclosed to users when obtaining consent. Different purposes cannot be bundled together under the same consent ask. And then, very importantly here, in order for consent to be valid, an active behavior with a clear view of consenting should be obtained. And then these rules apply to cookies regardless of whether the data accessed is personal or not. So to kind of condense these requirements, what this means is that consent to the use of cookies requires explicit, unambiguous, affirmative consent. Implied consent is, according to the court's opinion, implied consent, such as just a user continuing to use your website, even if you have a banner that goes up that says, by using this website, you're consenting to the use of cookies, not allowed. Having a pre-ticked checkbox where all the user has to do is click accept or continue does not constitute valid consent. They must make a positive affirmative action saying that, yes, I want to consent, and that they consent to the use of cookies, and the specifics about those cookies also be available to them in full disclosure. A few pieces that I pulled out here specific to that opinion that really kind of highlight that or those different findings or the summary that I just gave. I won't go through those here. You can read those kind of on your own when we send out the deck. So in terms of the ePrivacy guidance, what are the three pieces that I went through there? What is it speaking to? Basically, it's saying that consistently in more recent guidance, more recent opinions, the requirement for the consent to the use of cookies across the EU is one of explicit, unambiguous consent. Implied consent does not constitute valid consent, which means that we can't place access cookies until a user has consented to that activity or to that action. The implication here, again, around data collection, and I know I've said it a couple times, but just to really kind of drive it home, in order for cookies to not be placed, so for us to not place cookies until a user has consented, that means, from a practical standpoint, that we cannot execute tags in their kind of current form until that consent happens. Byproduct of that is that data is not being collected. Those platforms are not going to be running on your website. So analytics, Google Analytics is not going to be collecting information. Anything that's using cookies, so like maybe A/B testing platform, things of that nature that are leveraging cookies, cannot be run until that consent is given for the use of those cookies. So what is the impact on this? And then also kind of current status. What do we need to take away and what do we need to consider as we're thinking about our consent mechanisms and data collection and governance on our websites? The first item is just around consent considerations. We've covered that. It's just the requirement for explicit consent in order to place cookies and access any cookies. We also need to have those consent considerations as it relates to data being collected. So again, ability for users to opt out. And if we're using consent as our legal basis for processing of data for GDPR, again, it's still that explicit, unambiguous, positive, affirmative consent. One thing that can be a takeaway for your organization, these requirements, they're not easy. And from a technical standpoint, one thing that can really help significantly with managing the consent experience, as well as managing the just saving or the documentation around consent that users are giving, is the use of a consent management system. There's a number out there in the market that can really help with this. But basically what these do is it allows you to manage the banner that's showing up for users and manage the content and the disclosure, the transparency of various different cookies that you're setting, as well as data that's being collected, and easily give users a very easy ability to access your privacy policy where they can get more specifics. What this also allows you to do is collect that consent. So on like a banner or even a full page blocker, it allows users to make those consent selections. And then these are also providing some indications that you can use to then run or execute tags and collect data once those consent indications are made. But consent management systems, if you're not using one now, highly recommend looking into it or developing something yourself for your website. All of these things also, and one of the questions that's constantly getting more recently is around cookieless data collection. So as we kind of walk through the rules of the game, GDPR, CCPA, those big legislations speak directly to data collection. One huge concern with like analytics, attribution, any of those items is that by not being able to place cookies, as mentioned, the tags can't run, so data is not being collected. So how do we potentially decouple those two things and still collect data, but not place cookies? Now, there's going to be an implication there similar to what we had talked about for the ITP, where it's going to make some aspects of the functionality of those different platforms a little bit more difficult. Attribution is going to be more difficult outside of just like last click for a conversion that's related or happens within the same session as them entering your website, and also being able to identify users across sessions or across different points in time. Those become difficult or impossible without cookies, as well as things like audience creation and then targeting in a programmatic manner also becomes very difficult or impossible without cookies or other unique identifiers similar to cookies that would be placed on a user's browser. But there is still that possibility of being able to collect data so that you can still evaluate how are users interacting with your website, what do conversions look on your website, and I do see that as something that is becoming more pressing, and we'll definitely be seeing and hearing much more about that here in the future. But it also requires a change in a strategic kind of thinking as we're thinking about advertising, as we're thinking about analytics, is really doubling down on understanding who your customers are, and then using that more intimate knowledge of your high value customers in order to target them in a more contextual manner, as opposed to in that programmatic manner that is reliant on cookies and identifiers. Next thing in terms of just implications, one thing to really keep in mind and that you need to really address in order to be able to meet these requirements for consent and for data collection is around tag management policy and processes. Need to have really good tag management policy, governance policy, as well as processes for the introduction of new platforms, for auditing and understanding what's being collected now to make sure that cookies aren't being placed, cookies aren't being accessed for those users where these requirements are in place until consent has been given. Same thing with policy for any new platforms, any new tags being added to your website, making sure that they're following the rules of consent, and being able to identify where impacts of these different changes in the methodology for which we need to address this technology is happening. Another piece here is around just accountability. So within your organization, with your vendors, making sure that they're following these rules of the game, making sure that you are following these different requirements and these new guidelines for consent. And then also finally, a piece just around ongoing monitoring. One thing we work with the Tag Inspector, many organizations on first going through auditing, what data is being collected, what platforms are in use, what cookies are being set, what platforms are responsible for the placement of those cookies, which then informs that technical architecture for how do we manage consent, how do we make sure that we are properly following the consent guidelines prior to the execution of tags, prior to the placement and accessing of cookies by those different tags, and prior to data being sent and collected. As you go through that process, initially you can go through, you can audit everything, you can put forth the technical architecture and everything is going to be clean. But as time goes on, as requirements change, as some of these opinions or the guidance potentially changes from these different governing bodies, as new platforms are added to your website, things can go awry, and they often do. And there's a big need for ongoing monitoring, making sure that issues aren't popping up, because at the end of the day, a compliance violation, a violation of GDPR, a violation of some of these other laws and regulations is very costly to your organization. It also erodes consumer trust, which is really a core tenet and something that's going to be necessary in order to be able to gain that consent of users for any type of analytics, marketing, and advertising activities. Cool. So left about 10 minutes here, just for a little bit of summary and Q&A. Looks like we have a couple of questions that I can go through and try to address here. But to quickly summarize, some of the different things that we walked through here today in terms of tags versus cookies. Again, tags are the mechanism through which marketing, analytics, advertising platforms run on your website. They are responsible for both the collection of data as well as the placement of cookies. As we are restricting or as we are requiring consent for the placement of those cookies, the technical means by which you accomplish that is by not executing tags. The impact of that is that no data is then going to be collected until that tag runs, which, due to these requirements, that tag can't run until consent for the cookies or consent for that data being collected is positively gotten from your users. The rules of the game are the requirements for that placement, accessing of cookies, and those requirements for consent for the collection of that data are in those different laws and regulations. Again, if you want to do a deep dive on any of those specifically, there's some past webinars that we've done, a number of ebooks, and a lot of content on the Tag Inspector website that might be able to help out with those. We went through some of the more recent guidance around ePrivacy, so the requirements for consent as it relates to cookies. And then we talked a little bit about some of the impacts of those different laws, initiatives, and guidance on just your organization, how you can address some of those items. So now to get into Q&A, first one is, does the nature of the cookie impact the ability of the cookie to be set? For example, Adobe Analytics and Google Analytics are first-party tags. Can they set a cookie in user's browser without the user's prior consent? The ePrivacy, the regulations here do not make any type of a designation between first-party or third-party cookies. It's the use, the placement of any cookie on a user's browser. So no, regardless of if it's a first-party cookie or a third-party cookie, both of those scenarios would require consent. There is also, though, the only area, I guess, where first versus third-party cookies, where it matters what that designation is with some of those browser initiatives around privacy. So for like ITP, how a Safari browser is handling a third-party cookie is different from how it's handling a first-party cookie. The expiry on a third-party cookie is never going to be more than 24 hours. Typically, it's going to be capped at a session. So you realistically, for a user using Safari, third-party cookie is meaningless. It's almost like it's just being immediately deleted. Whereas a first-party cookie, at least it's going to persist for at least 24 hours, potentially up to 7 days. But the requirements for consents for the use of those, it doesn't matter if it's first party, if it's or if it's third party. Second question, who within a large organization would typically monitor or be accountable for all of this? So obviously a policy is going to be defined at the legal level. The problem that we run into, and what I'm hoping to be able to accomplish with webinars such as these, is to educate more of the technical audience on some of these different legal requirements, as well as to educate more of the legal audience on technically how some of these things work. Ultimately, the requirements of the on us for the following of laws, regulations is going to be more of a legal item, but the responsibility for doing so or for implementing these technical measures is going to fall on the IT team. So we need to be able to bridge the gap between the two and be able to understand the implications of these different requirements on the actual technology stack that we're using, and then put in place the proper technical safeguards and the proper technical architecture in order to make it happen. Question around if Tag Inspector has up-to-date information with regards to the latest news and updates involving data privacy. For any as they relate to tags, cookies, or like technologies, yes, typically we will be trying to summarize a lot of those things. We have these webinars very regularly in order to try to update and educate on the implications of these different changes. In terms of just like pure news updates, we're not putting out always immediately for just changes in ePrivacy or judgments or anything like that that's handed down. The best place, in my opinion, to go for those is the IAPP website, which is the International Association of Privacy Professionals. There you can oftentimes find, or actually always find, very up-to-date news on just updates to privacy laws, privacy regulations. They're not really going to cover the technical parts, but if you're looking for just constant updates around the privacy items specifically, that is a great place to go to. Question around explicit consent. Does it mean that we need to click via checkbox or acknowledge button? Yes, explicit consent is a unambiguous, positive affirmation or acceptance of consent. So what that would mean is ticking a checkbox and then clicking accept, or explicitly clicking some sort of like a accept all or accept or I agree type of a button. Yeah, explicit is just any unambiguous, positive, affirmative action. Do we need to audit our organization existing user information and ask them for consent? Very good question. Yes, that is also a requirement. If you are, for GDPR, if you are using consent as your legal basis for processing any of that personal data, the consent would need to be lawfully gained, which would mean that it would need to follow the requirements as outlined there. For explicit consent in GDPR. Again, there's some resources on our website that more explicitly break down all of those different requirements. That would also extend to, and that was actually one thing that didn't go into really deeply, but in that Planet 49 case, part of that opinion was actually that these requirements for explicit consent date all the way back to the update from the late 90s, actually, to the ePrivacy directives. So it's debatable, or it's being debated right now, if valid consent would extend backwards in time. That guidance has not been explicitly given, but it's if you are thinking about going through and kind of gaining consent for any information that you're kind of using or processing about users, it would be a good idea to look at that really holistically. Now, for the use of cookies, though, most cookies are not going, they're not going to be 100% persistent, so they're going to have an expiration date. So it's for sure a good idea, get that consent for the use of any cookies moving forward, at least for EU audiences. But yeah, potentially look into how we can regain consent and make sure that it is lawful as outlined within those laws and regulations for it to be valid. Question on if CCPA specifically dictates that consent must be given before cookies can be set. CCPA speaks only to personal information and the rights that users have with regards to their personal information. It does not speak to cookies. So there is no explicit requirement for any type of consent under CCPA as it relates to the use of cookies. These cookie laws are unique and specific to the EU and the various different member states within the European Economic Area. In the US at this point, none of these consent requirements would fall under any of those laws or any of those regulations. Cool. I see there's a few additional questions here. We're out of time, just to be respectful of everyone's time. We'll follow up on these items just via email. As always, please let us know if you have any questions, any additional items, or if you need any help with this, we'd love to discuss how we might be able to do so. So thank you all very, very much for attending, and hopefully we will see you on future webinars. Thank you.